In 1998 May, Asian Charter for Human Rights, which was a People's Charter, which went under the title Our Common Humanity, was launched in the city of Gwangju, South Korea. It was to coincide with the 50th anniversary of the Universal Declaration of Human Rights. However, the idea of having this to coincide was to demonstrate that the achievement of the goals of the Universal Declaration in the Asian context, which is also common to all other less developed countries, requires a new form of emphasis than what prevailed in the first 50 years of the UDHR. The emphasis we wanted was that mere declarations of rights was not enough. In fact, what is needed is implementation of rights. Why was that important? Because when a human rights convention is declared by the UN, the position in the more developed countries is that it will be accepted by their governments, and by that very acceptance it will be made into a law in their country, and once the law is made, there is a whole system to implement it. Now, what we were trying to point out was that in many of the Asian countries, even if you made certain rights incorporated into the law, it means very little, because implementation systems are highly underdeveloped, and in some instances they do not exist at all. Now, to clarify that, let us take one right. The most simple of among the rights is a right against torture and ill treatment. Now, of what use is the recognition of this right in the context of underdeveloped countries, when in fact the governments themselves rely heavily on torture used every day, almost at every police station, because that is the way they think the law and order can be imposed in many parts of each of their countries, particularly imposing of law on the poor. And the poor in these countries are the majority. For example, 40% of children in India are malnourished. Now, from there, that you can gauge the extent of poverty that exists in most of the less developed countries. Now, the result is that a law enforcement system, that is the essential system that is used in developed countries in order to maintain order, in order to maintain elimination of crime, in creating an environment of peace, environment within which the normal human relationships could be carried out. Now, that system does not exist, or exists only very limited way in most of the Asian countries. Now, what we are really talking is about the policing system, which is the main law enforcement, prime law enforcement agency in any country, which also has the duty of investigation into crime, and then the prosecutorial system, which has the obligation of prosecuting all crimes, and thirdly, the judicial system, which should prosecute crimes, and of course, added to that is the custodial system, prisons. Now, in all these aspects, the kind of glaring limitations are such that one could say that as far as basic rights are concerned, there is no implementation mechanism in any of these countries. To outsider, that may look like an exaggerated statement, but to people who know the inner story, it will be considered as an understatement. Let's take few examples. Now, in a country like Cambodia or Myanmar, both countries had a very bad past records due to internal upheavals. In case of Cambodia, ill attempted revolution which destroyed all the basic infrastructure of the state and resulted in also killing nearly 1 million out of the 7 million population. In Myanmar, the coup which took place in 1962 and the military regime that ruled thereafter till very recently had devastated the whole system of rule in the country, turning the whole system to serve the military purposes rather than what these things were created for at the beginning, for the basic protection of rights. So, vast change has happened in the social organization. The mere adoption of a UN convention does not change that internal subversion within the basic infrastructure that need to be recreated if the rights are to be respected. It should be a simple truth, but it is something that had not been within the generalized international discourse on human rights. People began to believe that, like a credo, a creed, if you say that you accept a UN convention, the matter is over, it will get implemented. Now, to understand that this is just nonsense, that is just that an act that has some symbolic value which may someday have a practical value, but at the moment has no practical significance, was not grasped. So, that is the reason why we said that we have to state these facts about the realities of our countries and then to ask, in order to have the right enjoyed by people of these countries, what kind of changes are necessary? What is the kind of human right work we have to do if we are to make these rights realizable in these countries? And that is what we try to address, and we worked on great detail on various aspects. It was a document that had also very innovative aspects. We tried to speak on the right to peace, right to culture, right to sustainable development, rights of women, and laying a lot of emphasis on that area. Also disabled persons. So, wide variety of rights which has already become part of the universal system of rights were restated, but always pointing to the fact that if these rights are to be of practical value to the people, there need to be institutional developments, and that the concentration of the human rights, those who want to work on human rights, should be on improvement of these institutions. There was a lot of participation in these discussions. It was not just a few people getting together and making a declaration. It was a process that went on for almost over 2 years. Many meetings were held in different parts of the region, South Asia, Southeast Asia, East Asia, and also in single countries. Many persons of different backgrounds, judges, lawyers, the human rights activists, women rights activists, and people have any kind of interest in human rights, including academics. These people participated, and at the end, large number of organizations and individuals signed the document, and these signatures are available at the end of the document. So it was a very significant moment when we declared that charter. Now the next question will be, what followed? What followed particularly was that the Asian Human Rights Commission, which is a regional human rights organization, took this charter as their working document and tried to spread the charter and the spirit of the charter in terms of discussions, particularly on the institutional developments which are required for the achievement of human rights. Now to illustrate that, we can take, for example, when we took the issue of torture and ill-treatment, we wanted to demonstrate how much this is very commonly practiced. So through an urgent appeal system, and the partners based on various countries collected information over a long period showing that a very sharp neglect is there about this right. And then when we collected these details of violations of torture and we tried to analyze that, then we began to see it is very directly connected to the nature of the justice system in these countries. That system could not remain as a system if the torture was disallowed, because the police during the peaceful times and the military during the times of unrest and conflict used torture as the main mechanism through which to suppress what they would say dissent. For the police, this is a method by which investigation into crime of most of the poor people takes place. As pointed out earlier, many of the people in these countries are poor. So if similar crime takes place, one where the culprit is suspected culprit is a very affluent person, the other, the suspected criminal, is a poor person, the treatment of the two will be so completely different. The affluent culprit could be sure not to be harmed by way of physical or psychological violence, whereas the alleged culprit, who is a poor man, definitely to be tortured, and in some instances this torture ends up by way of extrajudicial killings. And then a third factor has entered into this in terms of times of some internal conflict or unrest, where other than physical torture followed by killing, one more thing was added, the disposal of bodies. With that came the issue of enforced disappearances, which became a common factor in number of countries, sometimes in very large numbers. Now these, where torture is taken a very different kind of turn, and torture has become not only the way to deal with a suspect, but also meting out punishment without trial. So stories we collected about what was happening was telling a story about a completely different systems of justice. What was called justice there is what has been rejected as serious injustices in the more developed jurisdictions. In these developed jurisdictions, this kind of thing has happened in the past. For example, Middle Ages with the kind of religiously related Inquisition and such institutions where torture was allowed to be used, that belonged to that period, and there had been reforms, very determined attempt to eliminate this as a usual practice. Of course, in recent times there had been a return in partly to some of these practices due to anti-terrorism, particularly after 9/11 events in United States, and also even in United States in dealing with minorities, some forms of use of torture and also shooting still remains, but they are not the mainstream methodologies in dealing with crime. Whereas in developing countries, this is the way, the main way to deal with crime. We are talking about two philosophies, two ways of life, two ways of a legal system, entire huge contrast. It is this contrast that the global human rights community should grasp if they want to do any meaningful work in the developing countries. If they merely state principles which have been well accepted in developed countries and ask the governments to accept it by ratification and even making a law, which is all good, but that does not mean that the whole culture of what is called criminal justice, but it is a criminalized way of dealing with justice, that system does not erased off by ratification or by legislation. It does not get erased off. It has to be erased off by introducing methodologies of which are also used in developed countries to investigate crimes, which more forensic approach to that, and entrenching the fair trial as the method of determining guilt and punishment, and forbidding any other kind of punishment which is not sanctioned by judiciary, and by use of understanding of policing as civilized practice of investigation based on rational methodologies and documented evidence, which are used by prosecutors again to ensure only the criminals against whom there is adequate evidence are being prosecuted, and the prosecution is conducted in a civilized manner by way of fair trial before a competent and independent judge. Now, all these are things to happen. They do not happen. Mere writing of ratification or a passing of law does not result in this. It does not begin a process as it is assumed. So, we need a new discourse on human rights which has in mind that we must become relevant to the larger section of population living in the world. That is, people are living in the underdeveloped world are much a larger population than those who are living in developed countries. While the human rights discourse has originated and is relevant to the developed country population, to this larger underdeveloped country population, it is just far away from the real life of the people. How to get them closer to the real life? Only methodology is an institutional change. Institutions must begin to respect rights. It is the rights respecting institutions that can intervene in order to correct where wrongs are being done to people, correct it in the right way, and thereby raise the consciousness of the people about rights. When the country's institutions are themselves not respecting the basic rights, how could awareness of rights being created in countries? For many, many years there have been talk has been create awareness about human rights in these countries. How do you create when the institutions that exist in that country do not respect rights? People can always turn and say, well, where do you have these rights? If I go to the police stations, these rights are not respected. Prosecutors do not respect their rights, and for most part the judiciary is helpless, because if the police things have happened wrong, that will be repeated at fair trial and all that. So, the developed world must rediscover the actual human rights situation of the developing countries. Discovering what is there will help to develop a discourse, debates, discussions as to how to deal with the problem. First is there should be a discovery. If we close our eyes to the realities of the developing countries and merely preach them, do it this way, do it the other way, respect these conventions, and then once a year or so when there is a UN meeting, CAT committee or Human Rights Council, we make some load of recommendations, do it this way or do it the other. That has been done till 1964, when the Civil and Political Rights Covenant and Economic, Social, Cultural Rights Covenants have been signed, and annual meetings are being held, rapporteurs make reports. But if recommendations are made to be carried out without institutional changes which make it possible to carrying out of those recommendations, then the recommendations themselves are just empty words. They fill volumes, they can be exhibits, but to the ordinary person living in these countries it means nothing. To institutionalized person who is a policeman or a prosecutor or the judge, for them also it means nothing. So, this dichotomy has to be resolved, and the Asian Charter was a serious attempt to get this discussion going. Have we succeeded? Well, to some extent. Today there is a little more openness to this debate, because the documents that documented evidence about the proof of what we are talking about is overwhelming. We no longer are just telling our own statements, we are showing large body of evidence, and on the basis of that evidence it cannot be ignored. But this is not enough. There has to be more effort on the part of the developed countries to come to recognize this problem. The problem is recognized, as fortunately some rapporteurs have done. For example, the report last year made by the rapporteur for independence of judges and lawyers is an example of the way or the direction needed. That report analyzes the details of what is wrong with the police, with the prosecutions and also judiciary. Why these systems have failed or have many failures. And now that is a guide for civil society organizations as well as international community to intervene to make institutional changes. The new frontier that is needed in the human rights field is a concentrated work on institutional change, police change, prosecution change, judicial change. That will improve the rights of people, that will expand the freedoms, that will create an ethos within which the rights are respected both by the state and the people. Now, that is the discourse that we tried to introduce and have had some success in pushing it, and now we are going in on the 20th century to take it to a higher stage and learn to bring about the lessons we have learned into 3 more documents. Now, these 3 documents, which will be called supplements, the Asian Human Rights Charter of May 1998, are as follows. First supplement is on right to justice, and where the matters that I have talked about just now will be spelled out in great detail with the consultation with all the countries in the region. The second document is, or supplement, is on the right to peace, which is enormously important right in the present context. We are talking at a time when there is a serious conflict in terms of North Korea and the United States, which threaten the neighboring countries like South Korea, Japan and others, and in fact the whole of the region. And given the fact of nuclear factor, it could mean enormous destruction not only to the region, which may spark off far bigger conflicts for the whole world. We are living at times where the unimaginable destructions can be caused within few seconds, and that is a fact. And that is why the issue of peace, issue of negotiations, issue of non-provocation of dispute and magnifying of disputes into a large armed conflict to be avoided, and the peace among people to be encouraged and find different ways of bringing people into this discourse. Third supplement that we will be working on is right to culture. Developing countries have been left out of these rights in a very vast way. Large number of children grow without basic right of education, basic exposure to a culture, which means the rest of their lives they will live lives of slaves and lives of people who are unguided by any basic norms and principles of cultures. Culture as the moral foundation of societies, cultures of various kinds which have developed in these countries themselves, which binds people together. Now, these are issues which also need to be emphasized, because these aspects had not been talked about. Right to culture is one of the aspects that is completely missing in the public discourse. So, we hope to bring these and to bring a new vigor to the rights discourse, but on the other hand to bring the emphasis to implementation, practical development of institution culture, institutions and institutional cultures for resolving of problems.